Great. Well, I think the introduction gave the names, so I'll just point us out. To my immediate right is Attila, and then Justin, and then David. And I won't repeat too much of the background. I'll just simply say that Attila's been working on data regulation, data privacy, data issues for 20 years, maybe?
Yeah.
Right. And Justin has had a range of different roles, from negotiating what we call the US EU Privacy Shield to compliance in the corporate setting to some national security activities, so has a broad range. And David's been working on open source and the web for 20 years as a founder of MySQL, so a long experience in building transparency and openness into systems. Something that we haven't succeeded with yet with data, so I'm going to be very interested in the learnings there. So to get started, and I should say I'm Mitchell Baker from Mozilla. We've been focused on individual empowerment in all its forms, including privacy, but much broader, sort of forever. And so to start, the topic is, why do we still leave our personal data or give it to others? And that really strikes me as an unfriendly way to frame it. It assumes that consumers are dumb or lazy and just spewing data into the world for no reason, although it's very difficult or impossible to be online and not do that. And so I want to open the discussion up from the initial comments from why do consumers leave data to how could consumers not leave data, and what is it about the state of the system that really requires people to leave data. And so we're going to start with a brief comment, like a minute or so from each of the panelists, and then move on. So maybe I'll just jump to the center of the stage to be different and ask Justin to start off.
Well, thanks very much, Mitchell. I guess I'll address the question from two separate perspectives. The first is the challenges facing consumers right now. As you were saying, I've been on both the government side and I've been now working with very large companies. And it's a really interesting thing for me. If you go to most companies, set aside the consumers, if you go to most companies right now that are collecting personal information and you ask them, for the data I gave you, where are you storing it? What did you collect about me? And what other companies have you given access to that data? Most companies cannot answer those questions. I'll give you a quick example that illustrates it. When companies log every bit of contact that you have with them, they don't often dump that data into a relational database system. They dump it into file systems, and then they do analytics on it. So just that one decision, where you're splitting up the kinds of data that is being collected about a person, creates a real complicating situation in terms of a company tracking that data. And so forget about the consumer. The companies often don't know where it is, what they've collected, and all of the other processors in the chain that they've given access to. It's not that they're not protecting it, but trying to bring that basic transparency is very, very difficult. So then when you switch to the consumer perspective, if I go to my kids and I say, hey, here's a box of cookies, would you like to eat the cookies? They're going to eat the cookies. Why wouldn't they eat the cookies? They have no idea what the negative consequences are of eating a cookie. If you eat the whole box of cookies, they'll eat the whole box of cookies. On the other hand, if you start talking to them about the consequences of just eating only cookies, and all of the health consequences and so forth. First of all, you're a bit of a downer as a parent. But second of all, they start making some interesting choices about how many cookies to eat, right? And so I do think the lack of transparency in terms of what's being collected, how it's being collected, making it really easy on consumers to understand the fundamentals when they're making these choices, creates a really unfair dynamic fundamentally to the individual in making the choice. So even if you put the terms of service quite up front, there is just, I think, a fundamental lack of understanding and an ease to understand what data is being collected, where it's being stored, and who else has access to it to make that choice.
Do you actually, I do have a question whether there is actually any choice to be made. Like, I
No,
think that
that's-
might be a deeper question, and maybe, I know, David, you were speaking about that, so how about you?
Well, you have some sort of
Start.
choices. I tend to give incorrect information when I don't understand why people need the right one. I clear out my cookies in my web browser regularly. So we're talking about collecting data with a person. A lot of times the data is collected, you don't know it belongs to a person, depending which ID they have to the data. Most of the times you don't have a name, you know it comes from a certain IP. And a lot of the data is collected is just in small pieces, fragments. And I kind of care if it's, I don't care that much if it's a session from a web browser they get a little bit of data from and maybe showed an ad for that. But connecting to my identity, I don't like that. And being an ex-programmer, I can figure out how to stop it in most cases. But 99% of the word, as you say, don't know how.
And so this question of choice, like, do consumers have a choice? I think you, Attila, have been working on regulation, which is either giving a choice or requiring compliance. And so I just invite you to make a few comments.
Yes, I working. Thank you. I agree with you, but I work not in legislation, but in controlling the privacy. So we must protect personal data because privacy is a fundamental right, is a basic right, not only in the EU, but in all member states. Privacy is a constitutional right, and because of the internet is global, and that's why we have to create a common and global solution for protecting personal data. So that's why it is a very important and will be a new step, new regime next year with the European Data Protection Regulation, and with the new data protection regime consists of not only with this new general data protection regulation, but the directive on processing personal data on criminal purposes, and the new regulation on protection of personal data in electronic communication. So this will be the new data protection regime. And it means that we have to find the common practice also, not only the regulation, the legislation is common, but also the practice must be common.
So if I might, I'm going to play devil's advocate for a moment and ask, how will that legislation affect me as a consumer? Is it legislation that might make extra business for companies in compliance? Or is it something that I as a consumer will experience or have a choice? Or am I protected somehow?
The legislation is the same in each member state, and will affect not only the member state, but will affect the global data processing. Because all the principles, the legal basis, the rights, the solutions, and the consequences also will be the same in the European Union, and will be applied so will affect not the consumers in the EU, but in the whole world, because of this common solution. That's why will be a total new regime in the EU, and I think not only in EU but in the world. For example, through the privacy shield mechanism and other solutions.
And from your perspective, Justin, talking to companies that would be thinking about complying, does it appear as a compliance burden, or will consumers see it? Does it give us a choice or help us to not surrender data, or is it treatment afterwards?
First of all, you're asking a great question. I can't speak for everything. I mean, there's just companies I've seen that are doing the right thing and companies that are not doing the right thing. I'd say the great majority of the companies that we have seen are really trying to do the right thing. And honestly, you know those questions I pose, like, what is it, where is it, who else has it? Most companies, when you go talk to them, it's just not defensible that they don't know the answers to the questions. They even recognize it, right? They view it as an issue of fundamental trust. We were talking backstage a little bit about the fact that there are companies that understand that if you don't know what you've collected, where it is, and who else has access to it, you actually can't make intelligent business decisions about that information itself, right? You can't understand how you're supposed to use it. You can't make decisions about monetizing or opening the data to actually solve public problems. I don't mean to go too far off on a diversion, but when I was in the Obama administration, I had a really neat job. I had a great job. One of my jobs was we had to figure out how to take public data and how to solve public problems. And it was incredible. Like, for example, we could take census data and get it into the hands of the American Cancer Society and help folks who had just been diagnosed with cancer understand the demographics around their diagnosis. It was an incredibly powerful thing. And there were dozens and dozens of companies that were willing to build open tools for free just to solve that problem. But a lot of the data that we would have liked to have brought into that to help cancer patients, the companies couldn't figure out how to make decisions around it because they didn't know what it was they had collected, and they didn't have provenance over the data. They didn't understand really where it had come from and could track the consent. So I think there's a lot you can do in the future to solve public problems if you get better data hygiene around the information.
Oh, that's interesting, and it makes me think about this phrase personal data. And what problems we're trying to solve when we think about either regulating collection of personal data or privacy, and I can imagine a bunch of different problems that we all have. We've got them all under personal data. So I can imagine like the gathering of data about me that's used against me, whether it's surveillance or state action or denial of insurance or any other use of data about me for decision making. I can imagine personal data is troublesome for manipulation, and we've seen in particular, Russia is the obvious one now, but that the platforms themselves with the attention economy are increasingly adept at manipulating people when we don't know it. I can see, or there are issues about personal data that the value should be mine. So they're economic issues more than privacy or surveillance issues. And we have them all linked under personal data. And so I'm wondering, in your world or the software development, if you treat them differently, if we're treating them all the same, if we can solve a problem like personal data, or whether we should be looking at the uses of it, whether regulation treats them the same or differently. And might we make some progress if we started to think about the specific problems in personal data?
I mean, for me, one of the issues is that legal regulation can only do so much. In a lot of cases, how does it happen when you download an app and it's published in Asia somewhere? You don't even know which country. That app collects data. What's the legal state of that data? Which country's law? It's an American company who runs the App Store. I download a third-party app. I'm somewhere in Europe. Which jurisdiction is... Likely it's where I am that's the most important, but I'm not sure that's true. Right. And secondly, for a lot of the the billion-dollar companies has a lot to lose if they misuse the data. Smaller corporations, more on the edge, well, they don't have any billions to lose if they misuse the data, so they're more likely to break laws.
Right. So you're pointing out the regulation has got a difficult.
I kind of want to know who gets my data, and if it's a few huge corporations and governments who have it, then it's easier to keep track of. If my data is in 100,000 small companies' hands, I get nervous. And I'm not likely to have 100,000 apps on my phone, but I might have 100. And that's 100 people who know a hell of a lot more than Stasi knew about people in East Germany.
Yeah, I mean, I think of it often. I think the way you just separated it, it's sort of a boil the ocean problem. There are so many different ways to look at it. I do like the European way of thinking about it in terms of use cases. What is the use case you're talking about, and what are the problems? One of the ones I'll try and be a little provocative to my colleague to the left. Well, one of them obviously is state surveillance, right? All of the incredible amounts of data that comes up is a very important source for intelligence agencies who are looking at these issues. Europe often takes the position that, you know, we have very, very aggressive regulation, but actually the states, the member states in Europe have very, very liberal, permissive access to collect this data. Now, on one hand, they're trying to stop very important things. This is not just a one-sided debate, right? You have intelligence agencies that are trying to stop terrible, aggressive actors who are trying to do terrible things to innocent people. So it's a very compelling state interest. On the other hand, I think most of us want some limitations to that. And while European have a lot of commercial restrictions, the member states are actually quite liberal. I'll also tell you from the American side, I'll ask, I'm just going to tell you something. I'll ask how many people knew this, okay? There is actually a law on the books right now in the United States. It is an active live law. It's called ECPA. It was passed in 1986. And it says that if you have an email that was in your email box and is more than 180 days old, that the government can actually access that email without a warrant. They can just go collect it directly. Can I ask you, how many people knew that? So that is a crazy law if you think about it, right? Most people you know did not know that if the email is more than 180 days old, it can be accessed by the government with no warrant. And it was based on the idea that in 1986 there was no storage really online, so that if you kept something online for more than 180 days, Congress decided you waived your right to privacy on that data. Most people don't know that. So it's the kind of thing where regulation hasn't really caught up to where we are, and there's some troubling things on state access that come out of it.
It's interesting when you look at some of the modern European laws. If you just look at the text, they're really not that different from China. But the actual legislation is in the same part of the spectrum. Right? And so the difference we rely on is intent. And the Chinese government is very clear that their intent is to maintain the Communist Party in power. Like, that's part, that they're very clear about that. And the Western governments are clear in statement that the intent is not to maintain a particular political party in power. It's to enhance national security from terrorists. So the intent is wildly different, but the actual state rights in some cases are not very different. And so intent over generations is a kind of a weak differentiation for power. So I'm interested in the same kinds of questions.
Yeah, the national security is national competence in the EU. But each member state has to create real control on national security data collection. In Hungary, there is a draft which would give this right to our authority to control each national security secret information collection. And after the European court, just after the Schrems case, the United States had to create an ombudsman system to control the national security data collection. There was the first common control of this mechanism in September by the Article 29 working group, the European Commission and the United States. So this is very important, but it is not a common, there is no common solution in the EU, but each member state has to create a national mechanism to control the secret information collection on national security purpose. It's not easy, I know, but there is not only European Court of Justice decision, but there are some Strasbourg court decision which require the control mechanism to create a real control mechanism.
So I'm going to ask one or two more questions and then open it up if anyone listening has questions or wants to engage or direct. And so that's a signal to the folks in back about the microphones. Mm-hmm. So we have these questions of personal data, which as I mentioned, I think might be helpful to sort out a little bit what problem we're trying to solve. But when you think about the larger Web Summit, it certainly feels like the industry, by which I guess I mean the modern internet consumer industry, is really doubling down on the use of data, either at all costs or sort of an unrestricted use of data. And then, at least in the U.S. And in Europe, though in different formats, you have this set of questions about, do the companies have too much power? And these ideas of self-regulation, and at least the larger companies are trying to figure some way out about data. Maybe the smaller companies are doing nothing. But I note that over in the core Web Summit areas, like, it's really racing ahead at full speed. And so, my question is, do you think the industry will do anything on its own? Is change coming? Are the companies that are trying to comply a large or small fraction? And are they the companies that are really leading the industry? Who are they? And is there really hope, or is it only regulation, or is there some other possibility? Is there a developer or consumer movement that could possibly change things? So,
I mean, I talked to people in the management team of a large app developer, and they were nervous about using the data, using data in a way the customer didn't expect, or the users didn't expect. Yeah. So they had tons more data than they were willing to use, and it wasn't a legal thing for them. They were nervous of making their users nervous. So they wanted to slowly, give value when they used the data, and that had nothing to do with regulation.
Yes.
So they do think about it. But this was a quite large company, and they had a fair bit to lose. But the whole idea with the company was to be able to get value out of this data. Because they knew if you had GPS on in your phone, they knew which shop windows you were looking at. Because they could look where you stopped every morning when you way to work and etc. And then, of course, want to connect with that retailer and, you're interested in that shoes. But how could we do that without scaring the customer?
And your experience?
Honestly, I see we're working with a lot of companies at this point, small, medium, large. I see a lot of companies really trying to do the right thing with, and they've spent a lot of money protecting the data, securing it, using sort of technologies to make sure from a cybersecurity perspective they're taking care of it. It's almost though like trying to deal, like the old horror movie The Blob, right? The blob. You start with the blob. The blob is like there's a good faith scientist trying to build the blob for some good faith purpose. And then the blob gets out of the laboratory and the blob takes over the city. And the issue is with data, the way it's moved, the way it's stored, the way it's accessed, the way it's used, all for good purposes. At each step along the way, there's a very good chance that the data has spread around your enterprise in ways that are really, really tough to keep track of on an individual data element basis.
And so does the legislation change that? Does it add motivation?
Look, the legislation, I think, will be a great catalyst to do a lot of basic stuff in a lot of good ways. You know, just the fact that you have to identify it, you have to know where it is, you have to identify the nature of it. You know, one of the key things is the obligation to actually tell individuals what is it that you're collecting and why. That is a really important thing, right? Mm-hmm. To bring basic transparency. Mm-hmm. But
that's interesting.
But honestly, I see a lot of good faith folks trying to get their hands around it. But if you're in a multinational and you've been doing acquisitions of different companies, every company you've acquired has their own data stack. And most of the times, they don't move all of the information of the systems off of the old stack onto a unified stack. So you end up with Frankenstacks. There's just all kinds of different things that are integrated via API. So trying to map that gets complicated quickly. And I think, you know, having cloud infrastructure, among other things, really may be a very useful thing in terms of bringing transparency to it, because there's a lot you can do in cloud infrastructure to really bring scale to the process. So I think there's some great actors. I'm sure there are folks that are not doing the right thing with our information, and I think it'll fall to folks like Attila to track them down.
Yeah, so the GDPR offers, but not only offers, requires some solutions. Impact assessment, privacy by design, privacy by default, data breach notification. So the companies must apply these solutions because I don't like to say it, but if not, the fines will be very, very high level, 20 million euro. It's a huge fine, so it's very, very high level. So that's why I think the GDPR is good, because it offers the solutions. The reaction will be the same in the EU because the legislation is the same, and there will be consultations between the DPAs. There will be a new board, the European Data Protection Board, and there will be other mechanisms, for example, the one-stop shop mechanism, which means that there won't be differences, not only in the legislation, because it is the same, but won't be any differences in the practice, I think. But we have to wait for some years to get the same data protection level in the practice also. But we will work for it.
Well, I'm really quite interested in this idea that the basic regulation, or the idea of transparency driving business practice. And I'm interested in the application of that to the advertising world, and whether it actually does apply or not, because it is probably impossible to figure out what's happening. I mean, Google may know, DoubleClick may know, maybe not. Who knows if they actually are as all-seeing as we think. But certainly there's only there's only a handful of companies that could possibly know what's happening. And so it'd be very interesting if just knowing what data you're collecting from an advertising space, if that had to be given to the consumer. Do you think that's the interpretation of what we have now or coming?
Well, so, I mean, in the the U.S. versus EU approach is quite different, right? For a bunch of reasons. I think in the advertising space, there's been a lot of folks asking for something like the Fair Credit Reporting Act-like information for advertisers, where they at least have to tell you what it is they've collected and that you have the right to correct it if it's wrong, right? Yep. Fundamental things. From the EU perspective, there seems to be consensus around the fundamental idea that consumers and EU individuals must understand what it is you've collected about them and what you're doing with it and why. If that's not part of the regulation, then then there's something fundamentally wrong, right? Yeah. If the EU individual at least doesn't need to understand what you've collected, why you're collecting it, and that there has to be a purpose for it, then the regulation is probably, the fundamental goal of it is not going to be achieved. And my sense of it is that the Article 29 group takes this very seriously. They've been fighting for the GDPR for 20 years, and it took a lot to get it passed. My sense is that they're going to take seriously the idea of going and enforcing against companies that are not doing the right thing. And industries like advertising have to be at the top of the list in terms of what they're looking at, right, in terms of enforcement.
Right, so just following the flow of data is
that's exactly right.
difficult.
But, I mean, obviously Attila and David have a better idea of whether what I just said is true. But honestly, I can't see GDPR having teeth if that's not part of what it's seeking to do, right, fundamentally.
I think we're both looking at you, Attila.
So, I think because of the internet, because of the business, because of so that's why it was necessary to create a common solution, because the directive, to harmonize the directive. So now the data protection level is very different in the EU. For example, in Hungary, we are responsible for not only for data protection, but freedom of information. The most interesting case is the conflicts between privacy and freedom of information, but not each data protection authority is responsible for freedom of information. So we have very good practice in how to solve the conflict of transparency and privacy. And transparency is sometimes because of the business. So that's why I think we have to add our practice to achieve the common solution.
Well, if I add something, it would be a bit of a side. We talk about educating kids, but I think everyone should think about, why do someone needs to know this about me when you fill in something, or you download an app and you look at what permission it needs. Like you download a game and it wants to have your identity, internet access, Well, even if I like the game, I uninstall it immediately. I can't stand someone asking for permission that has nothing with functionality.
I said I would ask if there's any questions from the audience or any topics in our last couple of minutes here. So, yes, Greg. And there we go.
So thanks for the interesting discussion. I wanted to kind of also, maybe if you could comment, it's been a lot of the US EU focus, and I think that's important from a policy perspective because where the companies are. But have you looked at this within other country contexts? Because we're talking about issues of surveillance, came kind of as a subtext, or the data footprints. But in many other countries, this would create a large liability for people based on your political views, your religion, your sexual orientation. So have you looked at this through any other country lenses, or have you seen this as an issue also coming out in the countries you look at, whether US or UK perspective or EU? Thanks.
I actually worked on this, on privacy, not only in Europe, but also in the APAC countries. India is actually, there was an important Supreme Court of India decision that recognized privacy as a fundamental right in India, which is, this is an important thing because there's actually a lot of processing that goes on of data, both from the United States and Europe, actually in India as well. I see this issue on fundamental transparency around what's going on with your information as really going country to country around the world. The trickiest part about this for me is that right now a lot of that thought is going on a country by country basis, whereas data is moving almost like the way you would think of the sea moving, right? It's almost like maritime law. There's cross-country implications to every single thing that goes on technologically, and yet countries are trying to legislate this stuff on an individual country-by-country basis, and it puts a lot of us in the middle of real conflict of laws. I don't know if you all followed this Microsoft case that is being decided right now in the United States, but right now Microsoft is really in the middle of a fight between UK law and US law on what kind of data they have to produce to the government. So it's a tricky situation, and I think you're going to see countries around the world, if they haven't recognized privacy as some kind of fundamental right or a legislated right, recognizing it, and it's going to create some really interesting conflicts, not only from that perspective, but from a human rights perspective, from a freedom of speech. Sorry.
We're reaching out of time. No, that's good. That was really helpful. I'll just summarize very quickly, saying we didn't have a ton of ideas on the business side. I will say that's what Mozilla is trying to do. Not a pitch there, but that's why we have a technology arm. A lot about legislation, some possibilities, question of whether personal data is a useful topic, and onward from there. Thank you.
Thank you.
Thank you.
Thank you.